Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
I have the honor to announce on behalf of the court that the October 2024 term of the Supreme Court of the United States is now closed, and the October 2025 term is now convened. Today's orders of the court have been duly entered and certified and filed with the clerk. Mr. Clerk, the court will entertain motions for admission to the bar of the court.
Andrew Tutt.
Mr. Tutt.
Mr. Chief Justice, and may it please the court, I move the admission of Samuel Isaac Ference of the Bar of the District of Columbia. I am satisfied he possesses the necessary qualifications.
Your motion is granted and the applicant will be admitted.
Brian Shade.
Mr. Shade.
Mr. Chief Justice, and may it please the court, I move the admission of Priscilla Bonsu of the Bar of the District of Columbia. I am satisfied she possesses the necessary qualifications.
Your motion is granted and the applicant will be admitted.
Tina Fox.
Ms. Fox.
Mr. Chief Justice, and may it please the court, I move the admission of Jessica May Temple of the Bar of the State of Texas. I am satisfied she possesses the necessary qualifications.
Your motion is granted and the applicant will be admitted.
A group of attorneys from the U.S. House of Representatives, Office of the Legislative Counsel, presented by Donaline Roberts.
Ms. Roberts.
Mr. Chief Justice, and may it please the court, I move the admission of the following attorneys. Of the California Bar, Kakati Martha Davis Lynn. Of the District of Columbia Bar, Jordan Ann Code, Megan Hatcher Hawkins, Rebecca Hyuna Kimarcus. Of the Maryland Bar, Thomas Reinhard Cassidy, Brenna Aileen Culleton, Allison Elizabeth Hartwich. Of the Michigan Bar, Nicholas Andrew Yakumovich. Of the New York Bar, Michelle Orsi Vanek. Of the Pennsylvania Bar, Megan Lewis Chasnoff. Of the Wisconsin Bar, Allison Marie Gilly, Brandon Matthew Singer. I am satisfied each possesses the necessary qualifications.
Your motion is granted and the applicants will be admitted.
A group of attorneys from the Military Spouses JD Network, presented by Judge Patricia Millett.
Judge Millett.
Mr. Chief Justice, and may it please the court, I move the admission of the following attorneys. From the Bar of the State of California, Yesenia Haro Thompson. From the Bar of the District of Columbia, Caitlin Elizabeth Ames. From the Bar of the State of Georgia, Victoria Diane Starks Neighbors. From the Bar of the Commonwealth of Massachusetts, Hannah Ruth Marsdale. From the Bar of the State of North Carolina, Desiree Lynn Clem Kafel. From the Bar of the State of New Jersey, Jennifer Marie Young. From the Bar of the State of Nevada, Nicole Angela Corbett. From the Bar of the State of New York, Serena Lei Pong Tang. From the Bar of the State of Texas, Sarah K. Breckwald and Kelly Alicia Fury Stinner. From the Bar of the Commonwealth of Virginia, Juliana Marie Lyons. I am satisfied that each possesses the necessary qualifications.
Your motion is granted and the applicants will be admitted. If all of the applicants will stand, the clerk will administer the oath. But before he does so, I would like to extend to each of you a warm welcome as a member of the bar of the court and an officer of the court.
Raise your right hand, please. Do you solemnly swear that as an attorney and as a counselor of this court, you will conduct yourself uprightly and according to law, and that you will support the Constitution of the United States, so help you God?
We will hear argument first this morning in case 24557, Villarreal versus Texas. Mr. Banner.
Mr. Chief Justice, and may it please the court, during an overnight recess, the defendant and his counsel have a lot that they need to talk about. They need to go over the testimony that took place that day. They need to prepare for the testimony that's going to be given the next day. These are basic discussions that any competent lawyer would have with the client. This is the assistance of counsel that the Sixth Amendment guarantees. But the defendant and counsel can't have these conversations if they're not allowed to discuss the defendant's testimony. For example, If the defendant's testimony has gone poorly, counsel may need to advise the defendant to accept a plea agreement. But counsel can't do that without discussing the defendant's testimony. The defendant needs advice about how to testify without violating the trial court's evidentiary rulings. The counsel can't give this necessary advice without discussing the defendant's testimony. Counsel has an obligation to prevent the defendant from committing perjury, but that'd be impossible without discussing the defendant's testimony. Our brief has many more examples, but the point is that the defendant and counsel often must discuss the defendant's testimony during an overnight recess. Now, the court below tried to distinguish between discussions of trial strategy, which it allowed, and discussions of testimony, which it prohibited, but that's no line at all. It's often impossible to discuss trial strategy without discussing testimony. And responsible defense lawyers, worried about being held in contempt for crossing this invisible line, will be chilled from offering the assistance that the defendant needs and that the Sixth Amendment guarantees. The only conceivable rationale for restricting overnight discussion between defendant and counsel is to prevent impermissible coaching. But as the court explained in Getters, there are other ways to prevent coaching. There's no need to prohibit the defendant and counsel from discussing the defendant's testimony. I invite the court's questions.
In the judge's instructions, he says, I don't want you discussing what you couldn't discuss with him if he was on the stand in front of the jury. What's wrong with that?
Because if he was on the stand in front of the jury, they wouldn't be allowed to discuss.
No, he's saying, I don't want you discussing anything that you couldn't discuss involving his testimony before the jury. That's the standard for what's permitted and not permitted at that evening.
Okay, well, the trial court, if you read the entirety of the colloquy between the trial court and defense counsel, it's clear enough that the trial court prohibited all discussion of testimony, the defendant's testimony, during the overnight recess, and that is how the Texas Court of Criminal Appeals interpreted it. So the Court of Criminal Appeals interpreted I'm going to get the wording exactly right from the court's opinion. The Court of Criminal Appeals said, they described the question presented as, does a trial judge's sua sponte order that defense counsel could confer with defendant on everything except his ongoing testimony violate the defendant's Sixth Amendment?
So would it violate the defendant's Sixth Amendment right to counsel if during trial he was precluded from being coached or managed by his attorney?
You mean during an overnight recess?
No, during trial.
Oh, during trial. No,
What's
during
the
trial.
difference?
Under Perry, well, Perry drew a sharp line between overnight recesses and brief daytime recesses. And the court said that during a brief daytime recess, like I think you're talking about here.
What I'm talking about is, why is the standard different between what a lawyer can coach or manage with respect to testimony while he's on the stand, which is basically a concern, and what he can coach or manage during the recess?
No, it's the same. The distinction, let's be clear about the distinction between impermissible coaching and legitimate necessary counseling, right? Because that's a sharp line, and in answer to your question, that line is the same at all times during the proceeding. That is, whatever is impermissible before trial begins is also impermissible during an overnight recess. It's impermissible at any time, and let's talk about what that difference is, right? So the impermissible coaching is where the lawyer tries to get a witness, the defendant or any other witness, to testify, where the lawyer tries to change the substance of the witness's testimony, to try to get the witness to testify to something other than that which the witness believes to be true. But contrast that with conventional counseling, which is talking about the testimony in all other contexts. So, for example, advising how to comply with evidentiary rulings, even rehearsing the questions and answers.
But did any of that happen here? Do we have evidence that any of that happened?
It couldn't have happened. It didn't happen because the trial court barred the defense counsel from discussing Mr. Villarreal's testimony with him during the overnight recess.
Can I follow up
Counsel,
on?
if you One of the things you say could protect against any problems with your approach, I'm
Yes.
looking at page 14 of your brief, you say that the prosecutor could cross-examine the defendant after the,
Right.
when the trial picks up again the next day, as to the extent of any coaching. Isn't that a real problem with respect to the attorney-client privilege? What is the prosecutor going to say? Okay, you had a break, you spent the evening with counsel. What did you talk about? Objection, Your Honor. Attorney-client. I don't see how there could be a reasonable counterweight to the problems.
I understand what you're saying. The attorney-client privilege has never been understood to insulate a defendant or any witness from being cross-examined about the extent of impermissible coaching. So the dialogue would go, well, didn't your lawyer tell you to say that? No, he didn't. Or yes, he did, or something like that.
What did he tell you to say? You say, didn't your lawyer tell you to say that or whatever? And he says no. He said, well, what did he tell you to say? Or what did he tell you to change?
The court in Getters said, and we're merely following that the way to deter impermissible coaching is for the prosecutor to cross-examine the defendant about it. Now, you're right that to say that functionally it seems like it might raise the same sorts of privilege problems as having the court ask it, but that's what the court said in Getters, and not just Getters, subsequent cases as well, that with two appropriate ways to deter impermissible coaching. One is cross-examination by opposing counsel, and the other is just for the trial court to manage the schedule appropriately, do some, give some foresight to how long the defendant's testimony is going to last, and if the court is worried about impermissible coaching, just delay the overnight recess.
Counsel, I guess I don't understand why you're so focused on impermissible coaching as you have defined it. You say here and you say in your briefs that impermissible coaching is where the lawyer is trying to get the witness to change his testimony or whatnot, and that was impermissible both before and after and during.
Right.
All that's fine.
Right.
But that is not what I understood to be the concern here. Going back to Justice Thomas's point, the management of testimony, the talking with the witness about his answers and what some people would call coaching, prepping your witness, can occur beforehand, right?
That's right.
But it can't occur while the witness is on the stand. So Justice Thomas, I think, is pointing to a critical point, which is to the extent that the lawyer couldn't manage, coach, prep, practice with the witness while he's on the stand, why should he be allowed to do so during an overnight recess?
This is straight out of Perry. So the court in Perry said that during a brief daytime recess, the trial court can prevent all contact between the defendant and counsel.
I understand. I'm focusing on the content of the
content. No, I understand.
Right.
But
so Perry doesn't help us with that.
No, yes, it does. I'm getting to that, right? So the court said that after explaining all of that for a brief daytime recess, the court then in the next section 3 of Perry, the court says, well, overnight recesses are completely different. The court says, admittedly, the line between the facts of Getters, that's an overnight recess, and the facts of this case is a thin one. It is, however, a line of constitutional dimension. The court goes on to say during an overnight recess, it is the defendant's right to unrestricted access to his lawyer for advice on a variety of trial-related matters that's controlling. And then here's the key sentence: the fact that such discussions will inevitably include some consideration of the defendant's ongoing testimony does not compromise that
basic right. That's precisely what I'm getting at.
Yeah.
I think there might be, and I want you to help me with this, a difference between discussions that take into account the testimony, maybe even the fact of the testimony, and something that one could call managing or prepping or the kind of thing that you have even admitted a lawyer does legitimately to help his client before he takes the stand. And what I understood the trial court here to be doing was just eliminating that very narrow category of conduct that a lawyer engages in to actually prepare his witness with respect to particular questions and answers on
And,
the stand.
and that's the line the Court of Criminal Appeals tried to draw, right, between discussion of what you're calling prepping the testimony and discussion of testimony in other contexts.
And why are they wrong about that?
Because that line just, I mean, to even call it a line is wrong. It's not a line, it's a Rorschach plot.
But
right?
that's the line that Perry drew. I mean, if you go up a few sentences from the sentence that you read, the court says, you know, an overnight recess is different. Why is it different? Because an overnight recess will go to matters that go beyond the content of the defendant's own testimony, matters that the defendant does have a constitutional right to discuss with his lawyer, suggesting that as to only the defendant's own testimony, the defendant does not have a constitutional right to discuss with his lawyer. Now then it talks about how, of course, when you talk about the protected matters, there might be some incidental discussion of the testimony itself, so it concedes that perfectly willingly. But it draws a pretty sharp line between matters going to trial strategy and matters going to trial testimony of the defendant itself, and says that that's the reason why the recess, the overnight recess versus 15-minute recess makes a difference.
And like I said, that's no line at all. And the way you can...
But that's Perry's line. I mean, it might be that Perry was wrong, but that's Perry's line.
No, I disagree. Perry goes on to say that a defendant has an unrestricted right of access to his lawyer during an overnight recess, including for consideration of the defendant's testimony. So let me get, so it's, you're trying to draw the same line that the Court of Criminal Appeals drew.
Yeah, I'm not trying to draw it. I'm suggesting that Perry says it right here on page 284.
Yeah.
That's the key language from Perry. Now, Perry goes on to say, as I think your friend in Texas goes on to say, that there can be all kinds of places where the testimony has to be talked about as incidental to what is protected, which is the discussion of trial strategy, but not in and of itself.
Okay. First of all, I disagree respectfully with your view of what Perry held. But if Perry held that, I think it's just incorrect, right? So let's work through some examples. Before the overnight recess, in his testimony, the defendant has come an unsophisticated defendant has come very close to mentioning excluded evidence that would be absolutely devastating. During the overnight recess, defense counsel needs to say to the defendant, "Look, you nearly mentioned this evidence. Look, when we resume again tomorrow, you better remember not to mention that, because we're going to be in big trouble if you mention that tomorrow." Okay, is that consideration or is that discussion?
Mr. Benner, I think maybe I'm missing something, but I would think that would be permissible because it doesn't refer to the testimony itself. It can simply be a reminder, hey, don't go here. That might implicate.
No, but it does refer.
If I might finish.
Oh, sorry.
I think what my colleagues are getting at, and what I kind of thought you even conceded in your brief, is that coaching, and maybe we were defining coaching differently, perhaps that's it, but that there are some things that a district court can constitutionally prohibit counsel from doing while a witness is on the stand, even if there's a recess. You agree with that, right? You think there are some things that can be prevented?
Absolutely. Coaching, in the sense of suborning perjury, altering the substance of the witness.
Well, I'm not talking about suborning perjury. I'm talking about coaching.
Well, but
right,
we
if you don't like that word, let's use management, okay? Which is the word Texas uses.
I like that word even less.
Okay.
Yeah.
What in the Constitution, what in history suggests that you have a right to manage a witness's testimony during a break?
Okay.
As opposed to derivative or collateral matters that you do need to advise them on. There's a plea agreement, and the way things gone today, maybe we ought to take that plea. There's some excluded evidence. Be careful not to step into that. I can see all of those kinds of comments, but I'm having a hard time understanding historically, traditionally, what have you got that says that there's a right of a witness to be coached or if you don't like that word, managed by his attorney while he's not on the stand.
Okay.
Whatever the length of the court.
Yeah. So let's talk about the history. So the precise question presented in this case could not have arisen at the founding because defendants weren't allowed to testify until the late 19th century. Right. And so the question is, what's the appropriate inference to be drawn from historical practice? Right?
And historical practice is that once you become a witness, you are generally subject to the rule that you can't talk about your testimony. And that's generally understood to mean coaching and managing, but not advice about other legal matters. That's my understanding of the tradition.
I've got 3 points I'd like to make about the history. Okay. First of all, it's crystal clear at the founding and all the way till now that while the defendant, there are times when a defendant can certainly be denied access to counsel. When he does have access to counsel, he has a right to whatever assistance, including discussion of testimony, will be useful to him. Right. So while there's certainly historical warrant, as the government points out, both governments point out, there's certainly historical warrant for saying that there are times when a defendant lacks access to counsel. So, in a prison in the middle of the night or something like that, sure. But there's no historical warrant for saying that when a defendant does have access to counsel, the trial court can say, well, you can talk about topic A, but you can't talk about topic B.
Would your rule apply to witnesses who have counsel?
No, because non-party witnesses, they don't have a Sixth Amendment right that a defendant has. This is a rule specific to the defendant.
They have a right to counsel, and they've brought counsel.
During a criminal right to counsel.
Would it apply as well in civil proceedings to the defendant there?
No. The trial court can sequester non-party witnesses. This case isn't about that. This case is about the defendant as a witness.
In civil proceedings where there's a right to counsel, presumably? Yeah, it apply there.
I don't know. I mean,
it's just that there's a long historical tradition of witnesses going on the stand being told something like what the trial court said.
Non-defendant witnesses.
So, Mr. Benner, can I just clarify? You're entirely rejecting the line that Justice Kagan drew to your attention, and you're saying that even during the day, let's say it was an hour, you're saying this is all about time. So even if the recess was for an hour for lunch, you are saying that the district judge cannot restrict what the counsel and the client, the defendant, can discuss. That's
No. So again, this is Perry. Perry says that during a brief daytime recess, the court can cut off all contact.
But what if he doesn't cut off all contact?
Well, and then there's a footnote.
So you're saying that once the district court allows contact, no restrictions?
No, because there's a footnote in Perry, maybe here's what you're leading up to, that basically the greater includes the lesser. That is, where the trial court can cut off access to counsel, the trial court could allow selective access to counsel. But that logic doesn't apply during an overnight recess when the court is held. There's an unrestricted right of access to counsel.
So it's all about time.
It's all about time.
If it were 3 hours, if it were 4 hours, and it was daytime.
Well, look.
How do you decide when it's too long?
So in theory, there could be some hard cases between 15 minutes in Perry and overnight in Getters. I have to say, in practice, the lower courts have had no trouble drawing this line. Daytime recesses are usually pretty short. Overnight recesses are much, much longer. It's very easy to tell, to draw that line. Now, in theory, if a court were to say, look, we're going to have a recess from 9 a.m. to 5 p.m., and we're going to be like a vampire court and just do it at night, maybe
Okay, so your rule then is that any time during the day when there is a recess, the district court could, subject to maybe some extreme case where it goes on for too long and you have a vampire court, the court could say, you can talk to your lawyer about everything except the lawyer cannot manage your testimony during the day.
Again,
during the day.
During the day, again, because the greater includes the lesser.
Right. And you can't do that at night.
Correct, because at night...
It's unrestricted because Getters says that. So there's you can't have a line at night.
Well, Getters says that.
You can have a line during the day, but not at night, right?
Yeah, because Getters says that, but Getters was correct in saying that, right? Getters pointed out correctly that overnight recesses have always been times of intense strategizing, discussion, and so on. and whereas Perry said, well, not so for brief daytime recesses. Let me, if I could.
Mr. Bannock, can I ask you a concrete question? I mean, I can read Getters and Perry, but I'd like an answer to a concrete question. And let me give you an example. Let's suppose that a very important issue in a case is the meaning of Exhibit A. And in preparing the witness to testify, defense counsel goes over what the witness is going to say about Exhibit A. Doesn't put words in his mouth, but you know how it's done. So it's all prepared, a way of dealing effectively from the defense standpoint with Exhibit A. Then when the witness gets on the stand and is under cross-examination, the witness departs from that and says things that are quite damaging. Now, during a recess, overnight, or during the day, well, let's just say overnight, can defense counsel talk to the witness about that and say, look, the understanding was you were going to say this, but you said something different. This is very damaging. That's allowed?
Well, sure. Yes, the defense counsel can say, look, when we rehearsed this ahead of time, you were going to say A, B, and C. Right. But instead, you've said something totally different, which is D. Now, you've got to tell me which of these is actually correct. Because if you said D accidentally, then tomorrow we need to correct that in question. If you said
the next day when the defendant takes the stand, everything is cleared up. Now he's back to, it's a sea change, back to what was rehearsed in your words before trial. Can the prosecutor on cross-examination say, well, you said this yesterday, now you say this today. Did you talk to your lawyer last night? Yes. How long did you talk to your lawyer? Did you talk about this? Can he ask whether they talked about that issue?
Well,
is that a violation of the attorney-client privilege?
I don't think so. I don't think so because as the court's held several times, the proper way to ferret out any impermissible coaching is cross-examination, and then the prosecutor arguing to the jury, look, this witness is not credible because this witness was told what to say.
I mean, that's very interesting because I thought the core of the attorney-client privilege had to do with communications between the attorney and the client about important matters. But you think that the prosecutor can go into that?
Well, I mean, honestly, I'm honestly not sure. And maybe you're right. I honestly don't.
Well, it matters a lot because you're saying cross-examination is the corrective. All right. Suppose we've got a lunch break, 1 hour break for lunch. Two absolutely identical defendants. Both, Exhibit A is important for both. In one, there's a lunch break, and one, there's an overnight break. Does the same rule apply in those two situations?
You're right to suggest.
Well, don't tell me what the cases say. Just tell me why it would make sense to have a different rule.
Because you're right. I was about to do that. You're right to suggest that there are times when a well-timed overnight recess can be an advantage to a defendant that another defendant who doesn't get an overnight recess wouldn't have. That's absolutely right. But that is a result that is required by the Sixth Amendment because the alternative would be much, much worse.
Well, my question, I want to get to that, but my question has to do with a lunch break or a 15-minute break during the trial versus an overnight.
Right, that's what I'm saying.
Same
different
rule.
Different results.
Different rule.
Different
Why?
results.
Why?
Well, two reasons, right? One is that's what Perry said. We're just repeating the holding of Perry. You want to overrule Perry? I'm not going to complain, but that was the holding of Perry. But second, that it makes sense because, as the court said in Getters, overnight recesses have always been times of strategizing, discussions. This is the time when this is like prime time for in the middle of a trial is an overnight recess.
Yeah, if the defendant is on the ropes during cross-examination, an overnight recess can be very beneficial.
Very beneficial.
Once again, I'll continue this.
Well, can I just finish the answer?
Well, I didn't get the
You didn't get
question
okay.
out. I'll get to it.
Be back. Justice Thomas, I think, for Justice Alito.
Okay, once again, two absolutely identical defendants, two trials. 5 o'clock, the defendant is on the ropes in cross-examination. 5 o'clock rolls around. It would be really helpful for this defendant to have a break and get, and regroup. So the judge says, well, you know what, how much longer is cross-examination going to be? And the prosecutor says 3 hours. So the judge says to the defendant, well, you know what, we can go on until 8 o'clock, or we can take an overnight break, subject to the restriction that you can't talk about the substance of the testimony. What happens then?
Well, your latter alternative would violate the Sixth Amendment. During an overnight recess, you have a right to talk about your testimony with counsel. That's super, super important.
So a different result in those two situations.
It's the distinction between a daytime recess and an overnight recess.
Okay, one last thing. Can you give a succinct definition of coaching?
Yes.
Coaching is what's not allowed. You said you can't suborn, perjury.
Impermissible coaching is where the lawyer tries to change the substance of the witness's testimony. So you said before that in our just talking ahead of time, you said that the light was green. No, you should say that it was red because that's more helpful to your case. That's impermissible coaching. In fact, the court discussed this.
Yeah, you can't. The lawyer can't say, okay, well, this is what you should say.
Right.
But when you're preparing a witness, I mean, you could do the same thing overnight to get the witness to remember what the witness had said before.
Well, look, the other side, so what I just said was impermissible coaching. Conventional counseling is where the lawyer says, okay, I'm going to ask you this question. What's your answer going to be? The witness rather gives the answer. Lawyer says, look, that's a big jumble. Why don't you say it like this without just suggesting words, without changing.
Right, thank you very much.
Okay.
Ms. Sotomayor?
Am I correct to say that you say the only order a district court can give overnight is basically the ABA rule? A lawyer can only be prohibited from telling the defendant to give false testimony, correct? That's your definition.
Well, I mean, I would say.
Counsel, just answer yes or no.
Well, okay, mostly yes.
Okay. So assume, please, and don't fight me, that I think that Texas's position is more nuanced. And I accept that improper coaching that could be prohibited included walking through potential questions and answers, telling a defendant to use one word and not another word, what generally is thought of coaching. But Texas, and I think Justice Kagan defined their position, they can discuss incidental effects of testimony, and that would include, and pay attention to the list, plea bargaining, including telling a defendant that they did lousy and they should take the plea, perjury, you lied and you shouldn't, excluded evidence, the one that you were worried about, other witnesses and where they might be located, contact information. What else? What is missing from that list? Assuming the first bucket.
Yeah. So
you can't coach, you can't give questions and answers, you can't tell them to use a particular word or change a word, even if it's not perjury.
Okay.
Assume all of that. What's missing from that list? What other thing is missing?
Well, that list covers many of the most important things.
I just said.
But what it doesn't include is what you specifically excluded at the start, which is going over questions and answers.
All right, so if I say no to that, but say yes to the incidental effect, there's no other topic that you can imagine?
Off the top of my head, I'm sure there are others. I mean, a defendant and counsel have a million things.
Wouldn't the definition that Texas provides, which is the incidental effects of testimony, is okay?
That's no line at all. How is anyone
assuming
supposed to?
I believe there is the workability issue, there's no other topic you can think of.
Well, if you gave me a little time, I could probably think of more because there's an infinite number of things.
Now, going back to Justice Thomas's question, there's no facts in this record that would suggest that the defendant wanted to talk about plea bargaining, or the counsel wanted to talk about a missing witness, wanted to talk about perjury. There's nothing in this record to suggest any of that, correct?
That's correct, but the reason is that defense counsel understood the court to be barring all discussion of testimony, period, and the court confirmed that.
Counsel said, Judge, I understand what you're saying. I won't manage the testimony.
No, there's more. So the colloquy here is at pages 4 and 5 of the blue brief, right? So the court says, what you can't discuss is, this is the second to last paragraph on page 4, the court says the thing that you can't discuss is, the very start of that paragraph, his testimony. And if you look at the top of page 5, defense counsel says, we aren't going to talk to him about the facts that he testified about. Court says, all right, fair enough, right? So the reason why there's
We can read the transcript.
Okay.
Thank you, counsel.
Okay.
Justice Kagan?
Well, Mr. Banner, with respect, you have had a little bit of time since Texas's brief. And Texas, as I think you say in your reply brief, you say, well, Texas has narrowed the conflict a great deal and does come up with this set of examples of how discussion of trial testimony would be relevant to matters of trial strategy, and so could proceed during a recess. And it seems to me, like, unless you can tell me what other things there are like that, the Texas is basically saying anything that's relevant to larger matters of trial strategy, that should go in one bucket. But if all you're doing is going over the testimony, he said this, you said this, you might sort of think about adding this. He said this, but you explained it to me a little bit better when we rehearsed this. Is that what you're holding out for, to include that as well? Is that the only thing that stands as a difference between you and Texas right now? I'm not sure, honestly not sure if it's the only thing, but it's a more important thing than you're suggesting, because it's a common situation. So defendant says something completely surprising, something different from what counsel thought that the defendant was going to say. Overnight, they need to be able to say, oh, wait a second. When we talked before, you said A, B, and C, but now you're saying D, E, and F. Why is that? That is crucial for the assistance of counsel. It could be necessary to prevent perjury. At the very least, it's... Okay, but that's covered by Texas's... Well, but that was what I understood your question to exclude, right? You need to be able to talk about... I think what I'm suggesting is that the only difference between you and Texas right now is, like, let's go over the trial testimony and see if we can do it a little bit better. Yeah, well, let me put it this way. Our view is that you just have a right to talk about your testimony, period, right? Texas's view, as I understand it, is that the Sixth Amendment protects this list of 11 things you can talk about, but not this other list of 7 things that you can't talk about. I don't think that's fair. I think what Texas is saying, and Texas can correct me if I'm wrong, but it's pretty clear, which is that if the trial testimony comes up because it's relevant to trial strategy decisions, like whether to take a plea bargain, like whether to go find another alibi witness, like what to do about a piece of excluded evidence, et cetera, then you're allowed to talk about it. But it has to be incidental in that way to trial strategy decisions. It can't just be, oh my gosh, you didn't do that very well. Could we try to do it better? Thanks. But that is a trial strategy decision. That is how we're going to present our evidence is a fundamental trial strategy decision. That's a fair response, okay. But I take that to be the difference. Yeah, okay. I think that's right. I think it's a smaller difference than it used to be. That's right. Thank you.
Justice Gorsuch? Justice Kavanaugh?
I'm trying to figure out the logic of a line based on a 15-minute recess versus a lunchtime recess versus a lunchtime plus I have another matter I have to handle, so it's going to be a 2-hour break recess versus an overnight recess.
Well, the court in Perry said it's a thin line, but it's a line of constitutional dimension. If you're asking me to... Where does that come from?
Two things. Where does it come from? And what's the logic? Okay. Because it strikes me as not especially logical. Okay, let's talk about the logic first, right? So the Sixth Amendment guarantees the defendant a right to the assistance of counsel, right?
which should mean at the very least that if the government wants to limit the assistance of counsel, the government better have a very good reason for doing so, okay? And as I understand the logic of Perry, it's in large part a concern with trial management. If defendants had the right to confer with counsel during every tiny little recess, 1 minute, 10 seconds, or whatever, it would just be impossible to run a trial. So there has to be some, I think this is the holding of Perry, there has to be some line where a recess is just too short.
And what, I mean...
And where does that, I mean, the opposite part of that rule, where does it come from? The opposite...
And it all depends on as a question Justice Blackmun asked in the argument in Getters, it depends on the accident of a recess, which is a very... And then, the next page said you can't force a recess. Right. So the whole thing is treating two classes of defendants very differently. And this might be critical to the outcome of the trial. If the trial judge does a recess, you're golden, or at least a long enough recess.
An overnight recess.
Overnight recess.
Yeah.
Long enough recess overnight. But if not, Perry says no. And so those defendants are going to be treated much differently. And does that make a lot of sense?
I think it does, because as the court said in Getters, an overnight recess has traditionally been a time of intense discussion and strategizing. And the shorter you go in a recess, the less true that is until you get to 15 minutes and it's probably not true. But I understand Perry as really the government needs a very strong reason to override the right to the assistance of counsel. And I read Perry as basically that reason being just the logistics of trial management.
Thank you.
Justice Barrett? Justice Jackson?
So, I guess I don't understand your Sixth Amendment argument with respect to the defendant's ability to get that kind of management from his counsel during trial. So is it your position that a defendant has a constitutional right to consult with his attorney about the answers that he's given, turn to the judge and say, I'd like to have a moment to talk to my counsel while he's testifying?
No, of course not. There's no right to call a timeout during your testimony.
So why not?
Of course not.
Why not?
Well, I mean, a trial could barely go on if
so just pure logistics is what?
Trial logistics, I think so, right? Whereas the concern with trial logistics is it vanishes during an overnight recess when everyone's got plenty of time.
But Perry suggests that when we have a 15-minute recess already planned and it's there, why couldn't the lawyer talk about this kind of management with his client during that time? In fact, Perry says that's all that would be expected during that time, and that's precisely why we don't allow it. So I just don't understand. I don't understand your thought that the lawyer has the right, when his client is testifying, to talk to him about his questions and answers and coach him as to how to better answer the question.
Okay. I'm gonna quarrel twice with the framing of your question. First, he never doesn't have a right to coach him in the sense of impermissible coaching. He has a right to give advice about the wording of his testimony, not the right.
But just not during the trial while he's on the stand. But he can do that in a 15-minute recess.
No, he can't do it.
Why? What difference does the time make if he has the right to coach him in that way? What difference does the fact that it's 15 minutes versus overnight? If the Constitution says that a defendant has a right to be counseled with respect to his answers while he's testifying, I don't understand what difference it makes that we have a recess or not or whatever.
Well, okay, so but it's a distinction between a daytime and an overnight recess. That's the distinction the court drew in Perry. And like I said, if you want to ask me to justify that distinction, I think it's mostly just a matter of trial management. Because you think about it, if you say you have a right to counsel, to confer with counsel during a 15-minute recess, you can see the obvious questions: 5-minute recess, 1-minute recess, and so on. And so I think the court just said, look, at some point a recess is just too short.
Thank you.
Thank you, counsel. Mr. Warthen?
Mr. Chief Justice, and may it please the court. When the defendant's testimony is paused for a long break, the trial court may tell defense counsel not to either manage the ongoing testimony as we propose or not to discuss the testimony altogether as the United States proposes. Both rules are supported by this court's precedents. In Getters v. United States, This court barred absolute no-conformal orders during long breaks, but it never opined on qualified orders. Indeed, Getters himself would have been fine with such an order. In Perry versus Leak, this court allowed both absolute and qualified orders during short breaks, emphasizing the importance of untainted cross-examination to uncovering the truth. Perry reconciled its holding with Getters by noting that there is a constitutional difference between discussing ongoing testimony, which is not protected, and discussing other trial-related matters, which is protected. And as long as protected matters can be discussed, the right to counsel is preserved. Moreover, by allowing qualified orders, Perry necessarily recognized that counsel can indeed navigate such orders during short breaks, and there is no logical reason why they could not do so during long breaks as well. Accordingly, qualified orders allow trial courts to balance what the Constitution actually protects with the integrity of trial, and that's exactly what happened here. I welcome the court's questions.
After the night passed and there was no, you had testimony by Petitioner. Was there some objection to the judge's order in the sense that Petitioner said, or his lawyer said, that they were not allowed to discuss the matters other than testimony?
Not at all, Your Honor. When they came back the next day, the trial court asked them if there was anything to bring up. They said nothing from the defense, Your Honor, and they never filed a motion for a new trial. In fact, not only that, on top of that, my friends on the other side, they say the only way to enforce these orders is to say, well, what did you talk about last night? But that didn't even happen. The trial court just started his testimony up the next day, and everybody went on. It was assumed that they followed the court's order.
Mr. Warthen, I appreciate the subtlety of Texas's position as compared to the Solicitor General's more absolute rule. And I just have a couple of questions about that distinction.
Yes, Your Honor.
First, is there any reason why the court needs to reach the Solicitor General's more absolute rule in this case?
The only reason you would have to do that, Your Honor, is if you read the order actually given in this case more broadly.
I think that's right. That would be the only reason why we'd have to reach the government's position. You agree with that?
Yes.
Okay.
If you read it the way we read it, it would only be a managing order, a no managing order, not a no testimony.
And when we come to that, you've got, I think, the relevant language at page 23 in your brief, where the court says well, actually, where we said in Perry, that an overnight recess that would encompass matters that go beyond the content of defendant's own testimony, matters that the defendant does have a constitutional right. Those are protected. If we understand the trial court's order in this case to be consistent with that standard, is there any reason why we need to address the Solicitor General's proposal?
No, I don't believe so.
Okay.
If you believe it's just if this is a small, like, I guess you can conceptualize like this. If this is broad, this is a narrower kind of order.
And give me your best reason why that's the case here.
That this is a narrow order?
Yeah.
Well, so if you look at page 7A of the appendix, he says, I don't want you to discussing what you couldn't discuss with him if he was on the stand in front of the jury, his testimony. I'm not sure whatever else you would like to talk to him about when he's on the stand, but ask yourself before you talk to him about something, is this something that manages testimony in front of the jury? And I think what he's saying here is the only thing you'd want to do while he's on the stand testifying is go up there and say, you need to slow down, you need to stop shifting, you need to look at the jury in the eye, you need to remember the things that we talked about as far as the things you should say, here are the questions I'm going to ask you next. That's all managing in the way we define it. And then he tells him, just ask yourself when you're talking to him tonight, you can talk to him about something, and even gives an example of potentially if they go into a punishment phase, you talked about something, but if you're going to be managing his testimony, you can't do that.
And as Justice Thomas pointed out, there were no questions or follow-up clarification requests from counsel on that.
Exactly. He gave a little bit more clarification on his own after that, but there was no question about, well, can we talk about perjury, or if that's maybe a thing, or can we talk about potential plea bargaining? They didn't ask any of that.
Thank you, Mr. Warthen.
Counsel, let's say the defendant and the lawyer go into their, wherever for the evening recess, and the defendant says something like, counsel, you remember when we were preparing for this, we both agreed we should try to get the jury to focus on Fred. And whenever it's reasonable, I should mention Fred. And I've been doing that. And I notice every time I do that, juror number 8 gets a big frown and shakes his head. He doesn't look to me like he likes the idea of talking about Fred at all. So I think that's a bad idea. Now, talking about Fred was your idea. Do you still think it's a good idea? Can the lawyer respond to that question?
No. They would have to tell them I'm under a court order not to answer
So
that.
at that point, he tells the defendant who's facing a capital sentence, I'm not going to tell you. It's a very simple thing. Don't talk about, he's not saying particular things, but let's stop talking about Fred whenever we can.
Yes, that would be managing his testimony. That would be coaching and strategizing with him.
Counsel,
do you think that the
no, go ahead.
do you think that counsel can say, listen, I've been noticing that you've been mumbling, and you're also not making eye contact with the questioner, and it would just be a good idea if you stopped mumbling and made eye contact. Can the lawyer do that in an overnight recess?
No, I would consider that to be coaching their testimony. As far as how you present yourself to the jury, I would say that's also the same as the substance of what you're saying.
Yeah, so the line that you're drawing, and you draw this on page 14, and I just want to make sure that, that you're still saying what you're saying on page 14, where you say direct discussion, i.e. testimonial management, that is direct discussion of the testimony, right, can be prohibited. So whether it's the Chief Justice's question or my mumbling question, that's direct discussion. But counsel can still discuss a range of issues related to the testimony, including calling additional witnesses, plea bargains, legal objections, court orders, excluded evidence, and the implications of perjury, among others. So
Yes.
that's still the line that you're drawing.
Yes, the touchstone is always the lawyer should contemplate for a moment and ask themselves, is this going to cause me to manage their testimony? The way we define that is coaching, regrouping, strategizing about the testimony itself, not about other things related to you could strategize all you want about, should we still bring in the expert witness, things like that. But as far as how the testimony is ongoing, that would not be
And when Mr. Banner says that's not a line at all, what is your response to that?
No, I think that's a very real line because, one, the case law draws that line. And I think the logic of Perry is very strong. They say it's an empirical predicate of our system of justice that an uncounseled witness is more likely to tell the truth than one who has time to pause and consult with their attorney. And they say this rule applies for both witnesses generally and defendant witnesses. They don't draw a distinction between the two. And I think there's a lot of logic to that, because if it wasn't logical, then we would have to get rid of this rule for all witnesses. All witnesses would have to be, let's say that we flip it around. Let's just say it's the state star witness. So let's say the victim had lived in this case and it was an aggravated assault case. Why wouldn't the state be able to talk to the witness overnight and coach their testimony if the victim is not doing very well on the stand? The same logic would apply the other way.
Thank you.
Counsel, I think I might have missed the answer. The question was like, can you tell the witness to stop mumbling? You said he can't say that?
No, I would consider how you present yourself to the jury, I consider that to be also coaching. A form of coaching. Look at them in the eye, stop mumbling, don't talk as quickly, things of that nature.
What's the exact formulation, if you have one, of what the judge should say to the counsel before an overnight recess?
Well, I would say something like this, if for a managing order or a testimony generally. A managing order, if I were the judge, I would say, okay, I'm not going to go through an entire list of everything you can talk about. Whenever you're sitting there talking to your client, I want you to ask yourself, is this directly talking about the testimony, or is this conceptually, is this something that's a derivative matter from it? And in any event, regardless of what you're talking about, does this require you to coach, regroup, or strategize about the testimony itself?
Don't you think lawyers are going to have very different answers to that questions when they ask themselves that question? Yeah, I guess the point being, is that line really able to be applied in a neutral and equal manner?
They might have some differences of opinion, but we do trust lawyers to use their judgment whenever they are complying with any kind of court order. And our rule also allows any lawyer, if they're just not sure and they really don't want to run afoul of the court's order, to come back and ask the trial court and to say, Your Honor, I wasn't sure about this. Can I get some clarification or even maybe some reconsideration? And let's say it's like 5 in the morning or something like that, and they don't want to bother the trial court judge at 5 in the morning. They can wait till the morning, and they can explain the problem that they were having, and then they can ask for a continuance.
So that's important. That's your solution to ambiguity for the lawyers, is just come back and ask if there's something you want to talk about.
That's right.
Counsel, let me ask you about the government's, the Solicitor General's position, which we've now established is much broader. It's a no testimony order. What are your thoughts on the workability of that? I mean, the counsel on the other side suggests that there are all kinds of discussions that involve trial strategy that are going to be related to the defendant's testimony. So a no testimony order might be sweeping too broadly, or at least that's the argument. Do you have an opinion about that?
I think that it fits with the court's case law. I do. Our rule, their rule is a much more bright line rule. So in a way, it would be easier to comply with. But it's not as flexible. Well, our rule, the benefit of our rule is it maximizes the amount of conferral that an attorney can possibly have about the matters they do have a constitutional right to talk about. But at the same time, it excises as much as possible to protect the integrity of trial the things that they don't have the right to talk about, which is the substance of the ongoing testimony.
Counsel, Justice Gorsuch asked you, the facts of this case are really your position in this case, which is the judge's order only limited management. But the SG wants us to announce a bigger rule. Do you agree with that rule?
Their rule would, you're asking if I agree with that. I think it would be supported by the case law, yes.
All right. How would it be supported by logic? Putting aside, you agree that under any circumstance, a lawyer has an obligation, even we've said it in Nix, to not suborn perjury. If a client is perjuring him or herself, the lawyer just can't sit there and not do something about that. So that's the close case here. What can they do? You would say they can say to the defendant, if you commit perjury, these are the consequences, correct?
Yes.
If the government says no, that's really dangerous. How about plea bargain? The government said no in its brief to saying your testimony is really bad. You should reconsider taking this. If the lawyer doesn't do that, he or she is not supporting their ethical obligation to give the defendant information, adequate information to consider a plea, correct?
Well, I think in order to comply with court orders, you are able to
excuse the ethical obligation.
Well, yes, to a certain extent. I would be surprised.
Putting that aside, at what point do we accept the SG's position? Because an order that says don't talk to the person at all, we said in Getters, in Perry, was wrong. I'm sorry, in Getters we said don't talk to the defendant at all.
That's correct.
And so the question is where to draw the line. Should we ignore that line here?
Well, I think in Perry, they drew the line between testimony and not testimony. I mean, they even go so far in Perry as to say you can tell them not to talk at all because we're so worried that you're going to go talk to them about their testimony.
Right, but we said in Getters you can't do it overnight.
They say that was the context of that. I would say they'd say a long break, but the problem with, as was brought up earlier, drawing the temporal line between the two is a problem.
Makes no sense, so I don't. I do between what you can talk about and what you can't.
Yeah. Yes.
Thank you.
Sorry.
Please.
I want to just read you a potential instruction and tell me if you agree with it or if you see any kind of difference between your position and what I'm going to say and what the SG says. What if the court says, or what if we were to say that qualified conferral orders are okay if they tell the lawyer, listen, you can't talk about the content of the testimony or the manner of its delivery, but you can discuss any strategic consequences of the defendant's testimony, such as whether to take a plea, whether to call another witness, etc. Are you okay with that?
Yes.
Okay. And I'll ask the SG whether the SG thinks that's consistent too.
Mr. Warthen, I just wanted to quickly follow up on Justice Sotomayor's line of questioning. And I wonder whether unconstitutional conditions doctrine might be in play. If you were to say that a lawyer couldn't advise a defendant during a long break about collateral consequences from his testimony. If I can't advise you, boy, it's time to take that plea. If I can't tell you about the consequences of perjury, maybe I'm excused as an ethical matter because I'm under a court order, perhaps, but I would have thought that our unconstitutional conditions doctrine would have something to say about unnecessarily chilling the Sixth Amendment right that's at stake here.
Now, are you asking from the no management perspective or the SG's?
The SG's perspective. I wonder whether that implicates unconstitutional conditions doctrine.
I don't want to put words in your mouth, but I think the SG would say that there's two ways to go about dealing with, say, perjury. One, if you're still on direct, you can try to fix it up as you're going on direct. Or if it happens on cross-examination, you can try to fix it up on redirect. Another option would be the defendant finishes his testimony. You tell the trial court something very important came up during his testimony. If we could just have a moment to talk, if we can just have a little bit of time, then at that time you talk to them, you investigate whether or not perjury happened, you remonstrate with him about your ethical obligations and his obligations, and then you would call him back as a witness. And then if the trial court were to be like, well, why are you calling him back as a witness? You could either say, it'll become clear in just a moment, Your Honor, or you could tell them, you would just have to tell them straight out, perjury was committed and I have to fix it before the end of this proceeding. One other thing I just want to, since I have a little bit of time, is just the rule that we're advancing. It is the rule that I believe supports federalism. It's the rule that what they're asking to do is put a rule that is virtually unalterable because it would require a constitutional amendment. And we very rarely micromanage trial courts in that manner with these kind of constitutional rules.
Let me ask you about your perjury exception. So you say that the defense counsel could advise the defendant when there's a break during cross-examination, an overnight break during cross-examination, to avoid perjury. Would that allow defense counsel to help to clean up all inconsistencies between what the defendant said on direct and what the defendant admitted under cross?
So could you phrase that one more time, Your Honor, just to make sure I understand?
Yeah, on direct, the defendant testifies the way it was anticipated before trial and says A. And then on cross, the defendant messes up and says B, something that's completely inconsistent. Doesn't that allow the defense attorney to say, look, you're under oath, you can't commit perjury, clean up what you said on cross-examination? That would be allowed?
I would say this. You would want to investigate with them to see if there actually was perjury, and then you need to remonstrate with them. And then you would tell them, okay, tomorrow what we're going to do is we're going to clean this up. I'm not going to tell you how because I'm under court order, but just know, be expecting that tomorrow this is going to be fixed. You don't need to tell them, okay, here's the best thing to say, or, like, true or false. This is the best thing to say. I'm going to ask you these particular questions, so be expecting these questions. That's all strategizing. You couldn't do those things. But what you could do is just establish that perjury was committed and let the defendant know this is going to be dealt with tomorrow.
And how about the same thing with the question of plea bargaining? Could defense counsel say, wow, that was not good, because you were mumbling, because you were scowling, you better correct all that stuff?
I don't think that would be allowed. What we say in our brief is that you could tell them, we could say, you need to take the plea bargain. You might need to take the plea bargain because the state's case was so strong, but also if he just did a terrible job. And if the defendant says, well, how did I do a terrible job? You would just have to tell them, I'm under a court order. I cannot tell you why that's true. But you need to, in my professional opinion, you need to understand that the best course of action for you now is to take a plea bargain.
Now, why is that, Mr. Warthen? I mean, if you had said, as you do on page 14, that you can talk to the defendant about trial testimony when it's incidental to a big trial strategy decision, like whether to take a plea bargain. And the person says to you, I don't understand, like, what do you think went wrong? Like, why was it so serious that I now have to tell this? And you say, I can't tell you, just trust me that you have to take a plea bargain. And the person says, what do you mean, trust me? I mean, I want to understand, like, why this went so wrong that now I have to completely alter my understanding of what I'm supposed to do here. Like, shouldn't the lawyer be able to say, here's what went wrong, here's why it's really consequential, here's why you should take a plea bargain?
My time is up, but would I be able to answer, Your Honor?
Sure.
So the reason is because you're going to be managing their testimony, and the whole point of the order and all the logic behind Perry is that you should not be able to do that, because you're basically telling the defendant, well, if you stop mumbling, you start looking the jury in the eye, and you start giving clearer answers, well, then you won't have to take that plea bargain. It would be too easy of a workaround. Now, here's another thing you could do. You could tell them, I think this is going really badly. You probably need to take, in my professional judgment, you need to take this plea bargain. If they ask why, you say, I can't tell you that right now, but let's talk again whenever your testimony is over and see how it goes from this point on out and see where we are then.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Kagan? Justice Gorsuch?
I guess I would have thought that discussion would be incidental to the plea bargain. You say that you can discuss direct testimony so long as it's incidental to some other purpose. Why wouldn't it have been incidental in that case?
The plea bargaining is incidental. Like, discussing a plea bargain is a general matter, but the main thing about our rule, at least, is that you not then turn that into an opportunity to manage the upcoming testimony.
Justice Kavanaugh? Justice Barrett? Justice Jackson? Thank you, counsel.
Thank you.
Mr. Barber?
Mr. Chief Justice, and may it please the court. In Perry, this court held that a criminal defendant, like any other trial witness, has no right to discuss his testimony with counsel after that testimony has begun. That principle is consistent with Getters and with the long history of sequestering witnesses in order to safeguard the truth-seeking function of trial. Because a defendant has no right to discuss his testimony midstream, an order barring discussion of only that testimony and nothing else is constitutional, just as a defendant has no right to a timeout in the middle of testimony to confer with counsel. Petitioner's claim reduces to the assertions that qualified conferral orders are unworkable because testimony can't be distinguished from other matters, and unnecessary because courts can just prohibit coaching. But Perry squarely rejects both of those propositions, and it explicitly endorses qualified orders of the kind that was issued here. The court should therefore reject petitioner's request to categorically foreclose such orders as a matter of constitutional law for not only the federal courts, but all 50 states. I welcome the court's questions.
Under your approach, what can counsel discuss with the petitioner?
So there are many other trial matters, Justice Thomas, that the defense may want to discuss, from other witnesses' testimony to physical evidence to strategies for the upcoming closing argument, to grounds for appeal, sentencing matters. Under our line, they just couldn't discuss the testimony itself. And we think that's a clear and workable line. We don't disagree with Texas's proposed narrower approach to account for the narrower scope of the order here, but we think our line is very clear and very workable and consistent with the Sixth Amendment.
Why is your line? Sorry. Why is your line better?
We think it's somewhat clearer because we do think that there is some ambiguity about what management would mean, as Justice Gorsuch was getting at, how you account for incidental discussion of the testimony versus non-incidental. So, for example, we agree that there would be real concern to allowing the defense to say, or the defense counsel to say, you know, your testimony about this specific issue didn't go well today, and by virtue of those defects in your testimony, you should now consider pleading guilty. That does seem to us like, as Mr. Warthen suggested, an obvious workaround, and we do think that that would threaten the truth-finding function of trial. So our rule accounts for that. We think it's a reasonably clear rule because, first of all, it's drawn straight from this court's decision in Perry. This is exactly how the court phrased the scope of permissible qualified orders in footnote 8 of that decision. And defense lawyers could apply it, I think, pretty easily. There are always going to be edge cases under any rule, but the defense lawyer can always ask himself under our rule, is this a conversation that I would be having with my client, irrespective of whether he was testifying in this case or not? And if the answer is yes, then he can have the conversation with the defendant. And if the answer is no, then he should abstain.
Is this, I had trouble getting my hands around what you meant by this on page 28 to 29 of your brief. You list a variety of matters that are pertinent to the trial, and then you said those and other matters may be related to the defendant's testimony in the tangential sense that they bear on the trial context in which the testimony is taking place. A defendant and his counsel can conceptually discuss such matters without veering into the problematic ground of the ongoing testimony as such. I find that a pretty hard line to get my hands around.
I think, Mr. Chief Justice, our point there was that just because the testimony necessarily relates to other matters that the defense may want to discuss, the kind of matters that I was going through with Justice Thomas, that doesn't mean that you have a constitutional right to discuss the testimony itself. So, for example, if we went back to the plea bargain example, if the defense lawyer went into the recess and said to his client after the testimony had begun, I now advise you that you should pursue a plea bargain, we think that would be permissible, even if in the defense lawyer's head, part of the reason why that advice was being given was because he was aware, in the parlance of this court's decision in Perry, he was taking consideration of the testimony. That doesn't mean that you're discussing the testimony itself, and that doesn't mean that the kind of dangers to the truth-seeking function of trial are presented by that kind of discussion.
So he can ask them about all sorts of things that bear on the testimony, right? That might be pertinent in any other context that you say, are they the sorts of things you would talk about with your client without regard to the testimony? Or can the testimony at least narrow the topic of conversation you're going to have?
I think that, again, the topics that you would discuss can certainly relate to the testimony. We're not disputing that because the testimony is necessarily related to the other issues that are going on in the trial. All we're saying is that even under our rule, which is somewhat broader than Texas's rule, it is not a rule that you can't discuss, as Justice Jackson was suggesting, anything that relates to the testimony.
So
that's
you
not
can talk
the example.
about things that relate to the testimony, but you can't discuss the testimony as such.
Correct.
But what if I don't understand? You really are objecting to discussing any kind of downstream effect or strategic consequence, including the need to call another witness because the defendant on the stand may have introduced a topic that now the lawyer wants to say, do you know anyone who, you said X, so it would be good for us to call a witness to address that. Is there someone we can call? Not protected.
Correct. I think a couple points on that, Justice Barrett. So first of all, we are acknowledging the fact that our rule is partly prophylactic in nature. So we're not saying that the Sixth Amendment rule needs to be tailored specifically to communications that directly impede the truth-finding function of trial. We think that there is some virtue to having a clearer, more workable rule, even if you can imagine discussions under that kind of rule that would be prohibited that may not directly affect the truth-seeking function of trial. There's no narrow tailoring requirement here. The other important point I think I need to make is that we can all readily imagine, and we've been discussing this morning, important conversations that we have the intuition the defense should be able to have. But if Petitioner got his wish, and if all defense testimony or defendant's testimony were conducted continuously without a break, then by definition, this kind of opportunity for those discussions would not arise. So the opportunity to discuss potential perjury wouldn't come up because there wouldn't be a recess fortuitously intervening. So the notion that the Sixth Amendment rights of the defendant should turn on the fortuity of that recess strikes us as far-fetched, and that's what drove us to adopt the position.
That's what we did. You may not like it, that fortuity, but we created a difference between Perry and Getters. And I don't think the difference was based, as you think, on the truth-seeking functions. That has a reason for the order. But Getters was very clear that there is an independent Sixth Amendment right for advice of counsel. And what you're seeking to do is truncate that right overnight so that if the defendant mentions the name of a witness, He says, do you have the contact information for it? He's not affecting the testimony. He's not asking the witness to change it. He's not talking or evaluating the testimony. He's simply saying, give me an address. And you're saying no.
I wouldn't say no if you're just asking for the address.
Well,
because you
but
don't need to discuss.
you see, you're trying to cabin what is obviously not logical in your extreme position. The same thing with the plea bargaining situation. I find it impossible for a lawyer to say, I think you should consider a plea bargain now, and that the defendant is not going to say, but why? And the why has to be my considered judgment. That gets me from here to the corner and back with nobody paying me, okay? You need to say something. The model rule says a lawyer shall explain a matter to the extent reasonably necessary to make an informed decision. Now, if you have a rule that says you can't manage the testimony, but you can evaluate the testimony and say it was pretty bad for lots of reasons, that should be okay.
So I certainly want to repeat, Justice Sotomayor, that we don't disagree with Texas's rule. And if you wanted to say that because this order in this case was narrow enough to just prohibit management of the testimony, we're going to say that's permitted by the Sixth Amendment. That's fine with us, as long as you don't suggest that that's all that courts can do.
That's the no.
Because I think that's an important point. And if we got
that is an important point, because what you're asking us to do is to potentially say you can bar all conversation here.
About the testimony, but you can leave that matter for another day.
But why? Why would we do that? I guess I don't understand. If this order is narrow enough to cover the concern about problems with truth-telling in the trial because we're keeping the defense counsel from managing the way that it's been described, why would we go further to ensure that there could be problems with the Sixth Amendment by suggesting that a court could do more?
I think that just because this order satisfies the Sixth Amendment doesn't mean that a somewhat broader order could not, especially when we account for the fact that trial judges can be trusted to tailor these orders depending on the specific nature of the case, the nature of the defendant, the nature of defense counsel. We do think that there is some virtue to a somewhat broader rule, just in the same way that, and if I may continue, Mr. Chief Justice.
Briefly.
Just as we ban defendants regularly from having any contact with witnesses in the trial, we don't ask, can they be banned just from having threatening or detrimental contacts with witnesses? It's the same kind of principle here.
Thank you. Justice Thomas? Justice Kagan? Justice Barrett?
What's your view of what the original text and history would tell us about the proper rule pre-Getters?
That's a very good question, Justice Kavanaugh. So the root meaning of the Sixth Amendment counsel clause is simply the right to retain counsel. The amendment was adopted, or that clause was adopted to abrogate the common law rule that felony defendants generally had no right to counsel at all. One of the things that we think is very important in this case is that even the root meaning of the right to counsel, which is the right to counsel of choice, is subject to broad limitations. This court has said many times that a trial court has wide latitude to balance that right, that core right, against countervailing considerations like fairness, like the demands of the court's calendar. And that's another reason why it's appropriate to have a somewhat broader prophylactic rule and to reject a kind of narrow tailoring requirement in this context.
Justice Jackson?
I guess I'm still just confused as to why a narrow tailoring requirement. So can you just say more in response to Justice Kavanaugh? I mean, we have a Sixth Amendment right. I think you agree to have counsel have access to his client about trial strategy, about matters that he's allowed to talk to him about. And so in a world in which your prophylactic rule potentially encroaches on that because some of those trial strategies are intertwined with his testimony, I don't understand why we would give the court the ability to preclude discussion of any testimony.
So, Justice Jackson, we're just drawing the line that this court drew in Perry, and I think this is what Justice Kagan was getting at earlier. The court in Perry drew the line at discussion of testimony versus discussion of other matters, and that's the line that undergirds the basic holding of Perry. The idea is that because during the 15-minute recess at issue, which is taken sort of in the heat of the testimony when it's top of mind, the only thing likely to be discussed during that kind of recess is the testimony. That's the way the court phrased it.
And if we read that to mean testimonial management, what then?
Well,
not strategy as a result of the testimony, because we don't have time for that in 15 minutes. The 15-minute window in Perry, when it says you can only talk about testimony, what if we take that to mean you would be coaching your witness during that 15 minutes about what he just said or what he should say, and that's off limits?
Right. So if you agree with Texas and with us that the order here is reasonably read as just prohibiting management of the testimony, then this case is a very easy case, because Perry clearly says that that is constitutional under the Sixth Amendment. Leave for another day whether the SG is right about this potential broader rule. That's all you need to do.
Thank you.
Thank you, counsel. Rebuttal, Mr.
Thank
Banner?
I'd just like to make 3 quick points, if that's all right. First, under the Texas standard, the court should reverse. The trial court and the state appellate courts understood the order to bar many of the kinds of discussion that Texas now says is permitted. Second, the court's questions to my friends here suggest that the supposed line that Texas is drawing is no line at all. Lots of questions about what about this, what about that, and so on. Different trial courts are going to draw that line differently from the way my friend from Texas draws it. Defense lawyers will have no idea what they're allowed to discuss and what they're not allowed to discuss. And so, of course, they're going to err on the side of not discussing, as trial counsel did here. Finally, for decades now, the majority rule in the United States has been that the defendant has a right to the complete discussion of testimony during overnight recesses. It's been a very clean rule, unlike the rule that Texas and even the United States advocates. And it's the right rule because strategizing about testimony is one of the most important things that defense lawyers do. It's one of the most important kinds of assistance that defense counsel provides. Thank you.
Thank you, counsel. The case is submitted. Case 24-440, Berk versus Choy. Mr. Tutt?
Thank you, Mr. Chief Justice, and may it please the court. Delaware law provides that no medical malpractice complaint may even be docketed unless it is accompanied by an expert affidavit. That requirement conflicts with more than a half dozen federal rules of civil procedure. It conflicts with Rules 8 and 9, which set forth what a plaintiff must do to state a claim in federal court. And it conflicts with Rule 11, which bars verification and affidavit requirements unless a federal rule or statute provides otherwise. Given its unavoidable conflicts with multiple federal rules, Delaware's law cannot apply in federal court. Seeing that these conflicts are insurmountable, respondents seek refuge in Rule 11a, which says a pleading need not be verified or accompanied by an affidavit, quote, unless a rule or statute specifically states otherwise, close quote. They say statute in that proviso means state statute. But context matters, and respondents ignore it. A mountain of context confirms that the word statute in Rule 11a refers to federal laws, not state laws. The rule's text, context, history, and purpose make respondents' Rule 11a argument impossible. Rule 11 was meant to abolish, not preserve, a patchwork of state affidavit rules like Delaware's. Under respondents' reading, Rule 11 abolished nothing at all. Respondents call Delaware's rule substantive, but Delaware's law is procedural from tip to tail. It designates when a complaint can be docketed, what it must say, and when the defendant must file a responsive pleading. It doesn't define malpractice or alter any substantive standard of care. By its terms, it applies to all malpractice actions in Delaware, regardless of the state whose law governs the claim. And by its terms, it does not apply to malpractice actions brought under Delaware law in the courts of other states. This is a procedural law. The federal rules form a comprehensive scheme for the fast, fair, efficient resolution of cases in federal courts. Delaware's law cuts an ugly gash through that scheme. It has no place in federal court. I welcome the court's questions.
Was there a motion to dismiss filed in this case?
There was not. There was a motion to show cause in this case, at least on the affidavit of merit issue.
Is that the way? Is that normal under federal rules of civil procedure?
It is not. It is not the traditional way in which a case complaint's sufficiency is tested, or a case's legal sufficiency is tested. But it is authorized by the Delaware law. So the motion was made pursuant to Delaware's law, which permits a party to seek in-camera review, to ask the court to look at the affidavit of merit and determine whether it is sufficient. So that was the motion that was made by all defendants, and that the court then looked at the affidavit and determined it was insufficient because it did not actually include an affidavit.
So wouldn't this have been disposed of in a different manner had this not been Delaware or a state that had a similar requirement?
Yeah, this case would have proceeded instead to continue to expert discovery, where Mr. Berk would have been required to then have his expert testimony disclosed and go through the process of discovery on expert.
Why couldn't they have just made either a motion to dismiss and asked for it to be converted into a motion for summary judgment if an affidavit wasn't provided? They had.
Yeah, yes, Your Honor.
My point is that this is a totally different procedure, correct, than what the federal rules set forth.
It is a totally different procedure. It is a procedure created by the statute to facilitate the procedure created by the statute.
Can I talk to you about, I know you have a bunch of different rules that you say this violates, 3, 8, 9, 11, I don't know, 12. But the essence of all those rules is that the federal rules require a concise and precise statement of your claim.
Yes, Your Honor.
And that it has to be legally sufficient, correct?
Yes, Your Honor.
The affidavit rule, instead, is talking not about legal sufficiency, it's talking about factual sufficiency, correct?
So that is respondent's position, and I'm happy to embrace it because I think...
They're right, it's factual sufficiency, but that's not the purpose of the federal rules, is it?
No, not at this stage of
Not at the pleading stage.
Yes, Your Honor.
All right. Now, having said that, I think you were right in saying that for us or for the court to incorporate 6853, it would be a selective incorporation by us, right? The federal rules require that an answer be served in 20 days. The Delaware rule says the answer doesn't have to be served until the affidavit's filed. So it's changing all the federal procedural rules as well, isn't it?
Yes, Your Honor.
And that's also why we can't incorporate it, correct?
Yes. I think Delaware designed this statute for Delaware courts as a comprehensive scheme where each of the pieces fit together so that Delaware courts can apply this procedural requirement. But you could only, and I think respondents agree, only bring some of these requirements into federal court. It just would not be possible to bring everything from the Delaware law into federal court.
As you read the Delaware law, do you think it is even purporting to say what must be done in federal court?
We do not. We think it actually says that Delaware courts are to apply this rule.
And let me ask you this. If you had to concisely say, you know, as Justice Sotomayor said, you identify a number of different rules that you think preclude application of this Delaware rule in federal court. Let's put aside the Rule 11. Let's say I'm not persuaded by that. Concisely say to me, if we were going to write this opinion and we were going to say that under Hanna versus Plumer, there's a direct conflict here and so the federal rule has to apply, concisely say what you think the best rules to point to were. What would the reasoning be?
So Rules 8 and 9 set forth what a plaintiff must do to state a claim in federal court. And Delaware's law adds an additional evidentiary requirement that you have to.
But 8 says just pleadings, and an affidavit's not a pleading. So tell me why Rule 8 precludes this.
So Rule 8 precludes this because Rule 8 implicitly forecloses the application, the requirement that you come to court with a bunch of evidence, just as it would preclude coming to court with new particularity requirements or other requirements that you would have to put into the complaint.
How would your position, or what would your position be in, say, states that have these mediation or arbitration or board of review requirements to file med-mal claims before they come to court?
Those pose difficult questions for conflicts analysis under the federal rules. Each of them is different. They have very different requirements. Some of them are non-binding. Some of them create evidence that is then used on the merits later in the case, but because it's serious evidence against the plaintiff, it deters the suit. So it's not clear that all of them would pass, but I think many of them would pass.
But you think that deciding your case does not require us to say anything so broad as to say that states can't apply any kinds of procedures that try to address the problem that the Delaware law is trying to address?
Absolutely. Not only that, I think that this really leaves open an incredible array of ways that states can address the problem of medical malpractice suits.
Can you give some examples? Because the amicus briefs really focus on that, problem. So if you could speak specifically to examples.
So the most basic one that's always been known is attorney fee shifting. So if you bring a frivolous case, you're going to pay, or just a bad case even, you're going to pay your opponent's costs and their attorneys. That would be a powerful weapon against malpractice plaintiffs that are seeking strike suits. Obviously, states have enacted shorter statutes of limitations for these types of claims to make sure that if you suffer malpractice, you come to court quickly to assert it. They put caps on damages. They increased the burden that a plaintiff must carry to actually win one of these cases. So, for instance, you actually must prove your case in most cases through expert testimony. So at some point, a doctor is going to have to come in and actually say there was medical malpractice. You can't just come into court and say, I was really hurt. Jury, give me money because this doctor is, a wealthy doctor.
Well, is your argument reduced to the proposition that there is no such thing as a cause of action for medical malpractice in Delaware? What there is a cause of action for medical malpractice that is confirmed by an independent affidavit of another practitioner.
So I don't think that that's what Delaware has. I think that the clearest evidence is that this statute doesn't just apply to Delaware causes of action. So if you came into Delaware court and you were bringing a medical malpractice suit under Florida law, it would have to still apply. And I'll tell you why. The prothonotary is not to docket the complaint in Delaware court unless it has an affidavit of merit. But the prothonotary is not an expert in choice of law analysis, and so is going to just have to look at the face of the complaint. to determine whether or not it's a medical malpractice claim that requires the affidavit. So we think there actually is a separate cause of action for medical malpractice, and on top of it is a procedure that is designed to weed out certain suits by just putting in a procedural roadblock for the bringing of medical malpractice.
What if the claim under Delaware law had to be, what if Delaware law made it clear that a party cannot recover for medical malpractice unless the party submits an affidavit of the type that's involved here? It's a limitation on malpractice under Delaware law. That would be permissible, would it not?
It would not, under our theory of the case, be permissible because it would be an artificial distinction, as the court discussed in Shady Grove. It would be the same way in which the New York law in Shady Grove could have been written as an individual limitation on collective actions in each of the different penalty statutes. And the court said, whether you slice it and dice it like that or apply it as a categorical rule, it still works the same way. So in function, it is the same impermissible procedural requirement. And, you know, we think that there are just so many ways that this statute cannot apply in federal court.
Can I just ask you about one of them? Because getting back to Justice Barrett's question, I thought your sort of clearest, most narrow, direct conflict was with Rule 3. And I know that you mention it, but you really rely on 8 and 9 in ways that I don't know are necessary. I thought the theory was that we have this Delaware law saying what is necessary to file or initiate a malpractice lawsuit as a matter of procedure. You have to have this separate AOM. Notably, it's not evidence. It is just what is a necessary step to initiate this lawsuit. And under federal law, no such thing is required. The federal law says that the action commences by filing a complaint with the court. So why isn't that just clear, narrow, direct? It doesn't rely on any thoughts about factual versus legal. In fact, this is a factual distinction that could support a conflict, could it not?
Yes, Your Honor. I mean, we do assert that if there's a conflict with Rule 3, the part of the reason is that the lower courts on our side of the circuit conflict have really looked to Rules 8 and 9 and seen that as the fundamental sort of site of the conflict with the federal rules of civil procedure.
It seems more complicated to me because it does require, it's sort of piggybacking on what Justice Sotomayor was saying, we're looking at what is legally sufficient in 8 and 9. And Justice Barrett points out that this is an affidavit, it's not a pleading. There are distinctions there that I think would allow for a credible argument that there is no conflict because we're talking about later stages and it's evidentiary and all of these things. Whereas this initial point, like what do you need for the clerk to accept your document and start this case, is different in these two different realms.
Yes, Your Honor. And we obviously agree wholeheartedly with that theory of the case, and it really is as simple as that syllogism.
Well, if that were right, if you're just relying on Rule 3, Delaware goes and changes its statute and says you have to file it 20 days later, right? Then you don't have Rule 3 anymore.
That is true. That is the narrowness of it is that you would only be addressing.
Yeah, I mean the fundamental thing, isn't it, is the entire thrust of the federal rules, most particularly in Rule 8 and 9, which is it was meant to establish a notice pleading system where all you had to do was to say, here I am, here's my claim, I'm going to be seeking damages, the end, and everything else was supposed to happen later in the normal course of things. And then a defendant had a bunch of different opportunities, starting with Rule 12 and then continuing on with Rule 56 summary judgment, or using summary judgment even pre-discovery in various circumstances to get rid of the suit. And that's basically the structure of the federal rules.
Yes, and I think that puts the finger right on why we put so much weight on 8 and 9. I mean, this statute, like the similar statutes, is fundamentally at odds with that notice pleading structure that the federal rules rely on. And it creates lots of problems in federal court to try to import these sorts of things because all the other federal rules are built on the foundation of notice pleading. And the idea that the suit starts with the submission simply of this paper that says your claim for relief, your statement of jurisdiction, and your demand.
Mr. Tutt, what you say is compelling in a lot of ways, but your friend on the other side is going to say Gasparini, and that there the court did this crack and extract thing and took what they could of it and ditched what they couldn't. What do we do about Gasparini from your point of view?
Well, so the court determined in Gasparini, the court majority determined that there was no direct conflict with Rule 59. That Rule 59 provided a mechanism for the enforcement of the substantive New York standard for reviewing excessive jury verdicts.
Right. How would you have us distinguish it, is my question.
So we are a direct conflict case. So we are a Shady Grove case where, because a federal rule unavoidably conflicts, you don't get to the murky waters of Erie, which was
So
what
you
happened
think
back.
Shady Grove properly understood, and I think you're embracing even Justice Scalia's opinion that's not for the full court, says once we're in federal rules of land, federal rules of civil procedure land, we're not going to play with Hanna, we're not going to play with Gasparini. Is that a fair summary of your position?
Yes, that is exactly it.
And certainly there are some judges, Judge Ferguson and others, who would have us adopt such a rule. I appreciate that for the simplicity's sake for district courts. Can I just turn real quick to your Rule 11 response, because your friend on the other side makes a big deal out of it. And you say, well, it's distinguishable because it only speaks to federal statutes. And he's going to get up here, and I know he's going to say, well, look at the original federal rules of civil procedure. They expressly distinguish between federal statutes and statutes simpliciter. And therefore, when we see statute simpliciter, as we do in Rule 11A, we should encompass states. You know the argument. Okay. And assuming there's some force to that, do you have some other argument? For example, could one say that 11A has to do with pleadings and verifying the pleading, either the attorney or the plaintiff, defendant, whatever, has to verify the pleading, and an AOM ain't any of those things?
Absolutely, Your Honor. We could have developed this argument more in our reply brief if we had more words.
I wondered, yeah.
But there is a contemplation that, an affidavit and a verification have an understood meaning in federal court. And
with respect to pleadings, which that word is in the rule.
Yes, Your Honor.
And is an AOM a pleading?
Yes, and an AOM,
it's not by one of the parties. I mean, it's a third party document.
We concede it is not literally a pleading, although we think functionally, actually, they're trying to smuggle in the idea that you have to have a doctor come in and essentially vouch for you in your complaint. But I agree with you that it's not what we expect to see when we talk about verification of a complaint or we talk about an affidavit in support of a complaint, which is designed to support the allegations therein by the actual pleader. This is, I have to go get an expert witness who has to be a specially qualified person, a very precise person.
He's not pleading for you, he's an expert witness.
Right,
Thank you.
Yes,
Can I just go back for a second to Justice Kagan's point about notice pleading? Because as I understood it, this affidavit of merit is not discoverable, it's not evidentiary, it can't be admitted, it's sort of a black box thing. So why isn't that consistent still with a notice pleading kind of scenario?
I think this goes to something we call Schrodinger's law about the Delaware law. If it doesn't do anything evidentiary because it's totally secret, totally sealed, can't be used in the case, then it's got to be a pleading requirement, because what else is it supposed to be doing? It doesn't do anything.
So then where does the conflict come? I don't understand. I mean, it could be an additional thing. It doesn't have to be a conflict. If it is it seems to me that we only have a conflict from the standpoint of worrying about this extra thing that you have to require being in conflict with a notice pleading dynamic if the thing that is extra, this AOM, is requiring you to do something evidentiary in the course of the case, that it really is making a difference. It doesn't seem to me that from the Delaware law that this is even really evaluated by anybody. You just have to have it, and the court has to see that it exists, and then that's what is required to initiate your lawsuit. So how is that, maybe I'm not understanding, but how is that inconsistent with a notice pleading kind of dynamic?
The fundamental inconsistency is that you don't have to prove your case to file, or have your case already proven to come into federal court and plead your case. You know, it's
so you're equating this AOM with proof that you have a case.
It's adding an extra piece of proof that you need to develop before you even get the aid of discovery, right? So you don't get the chance to depose anybody about what actually happened. So you have to develop this expert testimony based on whatever facts are available to you, which may be a very limited understanding of what actually happened. But I want to go to this idea of adding something extra. We don't think you could make someone attach a contract to a complaint or attach an insurance policy to a complaint to plead a case in federal court. That would just be adding something extra under state law, but it would be fundamentally inconsistent with Rules 8 and 9, which don't say you have to do something like that.
Wouldn't it also be inconsistent with Rule 12D, which says that if you're going to be judging a motion to dismiss, it has to be on the pleadings alone, so you would be closing your eyes to these other things, so that if you disobey the Delaware requirement of attaching an AOM, that really has no effect on the court's assessment of any kind of Rule 12 motion?
That is our fundamental submission about Rule 12 and why we think there is a Rule 12 conflict here.
But it seems to me that that kind of dovetails with Rules 8 and 9 in showing you what the universe is.
Yes, exactly, and showing the interconnected nature of these rules and how if you could just add, if a state could make you add something to a complaint, it would have all of these domino effects on, well, what would be the motion by which you would then test the sufficiency of that? Delaware had to create a special provision for testing the motion because you're not allowed to see the affidavit, so you have to make a motion for in-camera review because you don't even know if it's insufficient.
Why Delaware has that sealing requirement? I mean, it seems to me it could be a couple of things. One, you want to protect the doctor who's coming in on the plaintiff's side from retribution and encourage him to come forward. Alternatively, you might be trying to protect the defendant doctor from allegations before and until somebody says that he's acted, someone in his profession has said he's acted problematically. Do you know the reasons why?
I don't know the reason, and there's even another possible policy reason, which is quite often in medical malpractice cases, the person who submitted the affidavit of merit went on a partial record, and so when you go to get an expert witness, you actually have to change horses because you don't want to have that doctor testify to the prior inconsistent statements. So, if there are any. So, there are numerous reasons that they might have tried to keep it.
I just wonder because if we're going to play the crack and extract game, in federal court, everything's got to be public, and do we defeat some of those policy concerns, whatever they may be?
Well, and I don't know how it could be kept secret in federal court.
Thank you.
Thank you, counsel. Justice Thomas? Justice Alito?
I don't know that we've ever invoked Schrodinger's cat in our analysis of statutes or rules, but what are you saying? Is the affidavit of merit a pleading for purposes that we've got Rule 8 and Rule 11? Is it a pleading for one and not a pleading for the other?
So the way that the statute is described in various places is either as it doesn't have any impact on the case. It's not evidence that's used at the trial. In fact, it has to stay secret. The defendants never get to see it, so they can't even use it tactically in the case. In which case, how is it evidence? It's just a procedural barrier. You have to just give the papers to the judge, and that's it, and then it's out of the case. And if that's true, then we do think that that makes it basically functionally a pleading. It's basically give us some secret allegations.
Under both rules, it's a pleading.
Say it again. I apologize.
Under both Rule 8 and Rule 11, it's a pleading.
We would say it's a pleading rule. So Rules 8 and 9 set forth the pleading rules in federal court, and it functionally acts like a pleading by creating more allegations. Imagine it wasn't the doctor who had to submit the AOM. Imagine you had to submit extra, particularity evidence to plead a case. All they've done is make the particularity requirement. They've assigned it to some other person who has to come in and substantiate your case. So in that
on the facts of this case, so your client hurt his foot. He was treated by a doctor in Delaware. Presumably, he got a report what the doctor did. Goes home to Florida. Maybe he sees another doctor. What discovery do you need?
Well, I think the most telling discovery could simply be asking the individuals at the facility where, so he alleges that when they were fitting him with medical equipment, they actually caused the injury. Individuals at the doctor's office caused the injury. Deposing them or deposing people who work with them could be helpful. Looking for contemporaneous communications. All these things are permitted, and in fact, they're the purpose of Rule 26. And so if you have, people sending messages to each other that say, like, we really need to change the policy where we just put this on people's feet, because it's probably malpractice, that would then inform another medical professional's ability to render an expert.
Could the district court grant summary judgment before allowing all that discovery?
Yes. I mean, under the federal rules of civil procedure, you would have to put in your 56D and say, this is what I need and this is why I need it, and the judge has a great deal of discretion in determining whether to.
Justice Sotomayor? Ms. King?
Just want to ask about the word conflict, because that's a word that means different things to different people, and just to make sure I'm clear about this. You're not suggesting, in fact, you're arguing impossibility is not the standard here. So even if it's possible to comply with the federal rule and the state statute, there still is a conflict because under Shady Grove it says, does it answer the same question, correct?
Yes, Your Honor. And I have been using a shorthand, but the test answers the same question. So addresses itself to the same question.
Right, and it's important, I think, to focus on that because the word conflict, like I said, can mean different things. Thank you.
Yes.
Justice Barrett?
Mr. Tutt, I want to give you a minute to address the Rules Enabling Act question. So let's say that we agree with you. Let's just assume that we agree with you and we think the federal rules answer this question and control. What do you think about the Shady Grove versus Civic, or Shady Grove and Civic question about what is the test for the validity of the rule?
So we wholeheartedly embrace Civic's test. We think it is the pre-existing law, and so it's whether it regulates the manner and means of enforcing rights. That's what makes it procedural under the Rules Enabling Act. So Justice Stevens in Shady Grove used a different test, said that Civic didn't set that forth. Even if you used Justice Stevens's test, this would pass under Justice Stevens's so bound up with rights that it functions as a substantive rule of state law.
Do you understand Justice Stevens's test to be consistent with Civic or a retreat from Civic, or what?
We don't consider it consistent with Civic. Justice Stevens took a different perspective on that, but the text couldn't be clearer of Civic. It's block quoted in Shady Grove for that reason. Look, it really says this. And it says as long as it's really addressed to procedure, it's valid under the Rules Enabling Act.
Thank you.
Justice Jackson?
Do we need to resolve any conflict between Civic and Justice Stevens's test in order to rule in your favor?
Only in the sense that you have to go on a longer journey to use Justice Stevens's analysis, unless you say, even using Justice Stevens's analysis, we would reach the same result here because he says it's a very high bar. It has to be, you have to have no doubt that it's bound up with state procedure.
Thank you.
Thank you, counsel.
Thank you, Your Honor.
Mr. Yarger?
Thank you, Mr. Chief Justice, and may it please the Court. Rather than identify one federal rule that applied here, in fact collided with the Delaware statute, Petitioner identifies seven separate rules and manufactures conflicts with all of them. All of those conflicts are entirely hypothetical. The trial court did not hold, and respondents did not argue below, that this case could not be commenced under Rule 3. Respondents never challenged the pleadings under Rule 12 or otherwise. Respondents didn't argue the affidavit had to be filed with the complaint under Rule 11 or disclosed in discovery under Rule 26. What this court held in Hannah is that trial courts in the federal system must enforce state laws using federal modes of enforcement, even though the federal rules are not identical to state court procedures. Here, the trial court held, and respondents argued only, that the Delaware affidavit of merit requirement had to be satisfied to maintain a cause of action for medical negligence under Delaware law, and because Petitioner couldn't obtain that affidavit, this case had to be dismissed. The only question in dispute under Hannah is whether the affidavit of merit requirement can be enforced in federal court at all. It can. It can be enforced through dismissal under Rule 41, as courts have held, or it can be enforced through early summary judgment, as both the Seventh Circuit and Third Circuit have held. Petitioner takes the extreme position that a federal court must ignore the entirety of a state statute if any part of it might conflict with a federal rule in some case. This court has rejected that approach, which is why Petitioner, in the briefing, effectively concedes that to prevail, he has to convince the court to overrule at least 3 of its decisions: Cohen, Woods, and Gasparini. That intrusion on the jurisprudence of Hannah is both unnecessary and would interfere with federalism. I welcome the court's questions.
You raised, though, the affidavit of merit argument in your answer and not in a motion to dismiss. Could you have raised it under another federal rule of civil procedure?
In fact, we simply answered the complaint, Justice Thomas. We didn't claim that the pleadings could not be closed. What we did do is we filed a motion for in-camera review with the trial court, and then the case proceeded, the pleadings were closed, and the case, in fact, entered discovery. There are at least 2 ways you can raise an affidavit of merit requirement consistent with the federal rules. As I said, Rule 41, B, which allows for involuntary dismissals. If a plaintiff cannot comply with a court order, here the court did order Petitioner to comply with the affidavit of merit requirement, or you can raise it through summary judgment. So either of those approaches are perfectly consistent with the federal rules and don't create any conflicts.
So, Mr. Yarger, suppose a state said, you know, this notice pleading stuff, we're really a little bit tired of it, and we want to go back to code pleading. And so we're going to enact a requirement, and it says, it's going to say for some category of suits, or for all suits, who knows, you have to do code pleading. We're not going to insist you do it in a complaint. You can just do it in a separate document. Call it an affidavit of merit. Call it a non-pleading if you want to, but it's got to be filed very early in the lawsuit. Would that be all right?
If it's an affidavit that's separate from the pleadings,
that's what we're calling it. We're calling it an affidavit of merit.
Of course, my position is you can enforce that. I think the question
is... So
you
can enforce that. I mean, that is like exactly what Rule 8 and indeed the entire structure of the federal rules was designed to prevent. If there was one thing that the federal rules did, it was to say notice pleading uniformly throughout the nation in federal courts.
And this is not a rule of pleading, which is our point. The pleadings itself.
But the hypothetical I'm giving you is all we do is call it something different, and we're back to a code pleading system.
Understood. And if that's the case, Your Honor, Erie, of course, is going to kick in. And that's the second step.
I don't know how why do we have to get to Erie? I mean, it's just got to be the case under Hannah, et cetera, that you look at Rule 8, you look at Rule 9, you look at Rule 12, and the whole package of it says no code pleading in federal courts.
If it in fact conflicts with Rules 8, 9, and 12, which the affidavit requirement here does not.
Well, I guess the question is why it does not. Okay, I'll give you some more examples. Suppose there was a state that said, too many darn contract suits. So we're going to make people come up with affidavits from an economist denoting all the different damages that apply. And we're going to do this also. You've got to do it within the first 10 days.
I think the key question in all of those cases, Your Honor, is how do the parties bring those issues to the trial court and present them through the rules of civil procedure? There are mechanisms.
Well, I guess what I'm suggesting is that you don't do that through the rules of civil procedure, because the rules of civil procedure, although they don't say you cannot apply additional requirements like that, the rules mean in the same way that they meant in Hannah, in the same way that they meant in Shady Grove, that no, if you try to impose requirements that make medical malpractice claims, contract claims, trade secret claims, on and on and on, if you make them subject to special requirements whereby the plaintiff has to come forward with some sort of proof that their claim is good before anything starts, that's inconsistent with the entire structure of the federal rules.
Sure. So a couple of responses. One, the affidavit here is a separate requirement apart from the proof and the evidence in the case.
I mean, we're going to label all of these affidavits. You have
Understood.
You have to file your trade secret. You have to file your economist's report. You have to file an affidavit if you're in a car accident from one of those accidentologists saying that the thing was your fault. It was the defendant's fault.
Sure.
I mean, every kind of suit has something that you have to prove, and we're going to make you file something before the suit gets started about why it is that you're going to be able to show in the end that you meet the elements of the suit.
And I bring up the fact that this is outside the evidence and outside the pleadings because it's much more like the bond requirement at issue in Cohen, which was a requirement that the state of New Jersey had placed on certain types of suits, derivative suits. And it could be raised at any time during the course of the proceedings. And if it was not satisfied, the case had to be dismissed. And Petitioner, that's why Petitioner wants the court to overrule Cohen, because it's a significant barrier that he has to affirming application of Delaware's affidavit of merit requirement in federal court. It's not part of the pleadings. It doesn't constrain the evidence. In the case, the Delaware Supreme Court has said that very clearly. It's a separate requirement necessary to demonstrate that a plaintiff has done the appropriate consultation with a medical expert to say just what the statute says, which is that there's reasonable grounds to proceed. Our only point, and I think the only question under Hannah, and this is very important, is that if those requirements can be enforced in federal court using the federal rules without any conflict, there's no occasion for a federal court to disregard the requirement in all cases for all time forever in federal court, which really is Petitioner's position. In Hannah, the conflict, Justice Kavanaugh, was unavoidable. That's what the conflict has to be. There was no way for the court not to adjudicate the conflict because the trial court had dismissed the case due to the method of service the plaintiff had decided to use. It was either apply the state rule of service or the federal rule. There was no choice between the two. Here, at no point did any party or the trial court attempt ever to do anything that created any kind of conflict with the federal rules, which is our point. And if Cohen can allow states to regulate causes of action for shareholder derivative suits, which are wholly within the state power to regulate, Delaware ought to be able, like most states, regulate medical negligence claims, which the parties agree are entirely within the power of state legislatures to regulate.
What about the conflict with respect to the timing of responding to the complaint?
Well, it's the same answer. There is no conflict. There was no conflict.
But I'm saying under Rule 12,
sure,
you have a certain amount of time, and it runs from when the complaint is filed. Under Delaware law, you have a certain amount of time, but it runs from when the AOM is filed, and those don't have to be the same thing because you could have gotten an extension for the AOM.
Right. And our point, again, there was no conflict here because we actually answered the complaint the pleadings were closed. Had we wished to enforce that requirement, we could have filed a motion under Rule 6B for an extension of time.
But looking only at the rules,
The federal rules.
Yes, both
Yes.
rules. I mean, don't we have a conflict just on the basic question of when is your answer due?
I don't think you do because it's Rule 12 unless you move for more time. And in that way, the conflict would never arise in federal court unless you brought it to the court's attention and said, I don't want to answer this complaint. I want to pause everything in time for plaintiff to obtain an affidavit of merit.
You're rewriting the Delaware law. The Delaware law doesn't require you getting permission for an extension. It says you don't file an answer until the affidavit's served, period. So you're now rewriting the Delaware rule to fit it into the federal rule.
Well, I wouldn't say we're rewriting it. Everybody agrees.
You're rewriting it so that it's convenient.
Everyone agrees that an affidavit of merit has to be obtained. The Delaware courts have freely granted extensions to obtain those affidavits. They've even said that an extension be granted after the fact.
But now you're telling federal courts they must.
Well, what I'm saying is that unless and until a federal litigant comes into court using federal modes of enforcement, which is what Hannah said, and raises the issue for the court's decision, and there is a conflict, there's no occasion to use
Thank you,
Hannah.
counsel.
Well, Mr. Yarger, let me just pick up on that with you for a second. So, as I understand the Delaware statute, you must file this under seal. Nobody looks at it except for the judge. And in fact, it's supposed to be filed with the state clerk, and they call them something else there, but there you are. And the case cannot proceed. Whereas I think you're acknowledging in federal court that wouldn't apply because once a complaint is filed, the case is off and running, and that's a public document, and you have to answer or move within a certain number of days, right?
The affidavit is a public document?
Well, no, the complaint in federal court is
correct.
a public document, and that's all that's required to get the case up and running, and a defendant has to respond, right? So that there's a delta there, and you are cracking and extracting, as your friend on the other side likes to say, some things from the Delaware rule that you would apply in federal court and other things that you wouldn't. Isn't that fair?
Well, I think that is true of many state statutes and substantive rules laid out in state court decisions. It's never been true of Erie that in order to apply state law in federal court, you have to take every single sentence written by a state Supreme Court and apply that in federal
Well, how do we know what the Delaware state legislature would do? I mean, we're creating this Frankenstein of a statute, right? We're taking bits and pieces and adapting it. And I understand your point, but what authority does a federal court have to rewrite Delaware law in that fashion? And, you know, I mean, maybe the affidavit has to be public and discoverable in federal court. And that seems wholly antithetical to the statute. Whatever the purposes were for making it private, there are obviously good and important reasons for keeping it private. And for it to precede the suit and not to allow the suit to get off the ground. Those were all important policy judgments we would just be paving right over in federal court. What do we do about that?
Sure, so let me answer the confidentiality issue first and then the broader question. The confidentiality issue is easy. It's a state law privilege that federal courts have to enforce through Rule 501 of the Rules of Evidence. Sealing is just the mechanism by which you assure.
Would it be discoverable by the other side, though, even if it's sealed?
No, it's not discoverable. It says
it's not discoverable in federal court.
Because it's privileged. Huh? And privilege is a tremendous.
Is it privileged?
Yes, it's privileged. It's tremendously important in medical negligence cases. Doctors face lawsuits all the time.
We know that it is privileged. I understand it's supposed to be filed under seal. Is that a recognized privilege under state law?
Under subsection D of the statute, it is not discoverable. Well, that is privilege.
I understand. Oh, okay. All right. Well, all right. Put that one aside. Take the broader question that we're picking and choosing, and by what authority do federal courts have?
Well,
and I'll be interested to see what Mr. Tutt has to say about the discoverability point.
Sure. one easy place to look is the Delaware Supreme Court. And there is no dispute that if a plaintiff can't obtain an affidavit, even after the 60 days after the fact, a case has to be dismissed. We've cited some cases in the briefing from the Delaware Supreme Court that apply the statute fairly flexibly, giving plaintiffs more time even after the time has expired. But the one thing they do say is that if you want to maintain the cause of action under state law, you have to obtain the affidavit. And this really was part of the reasoning of the Seventh Circuit, and the Third Circuit has held the same thing. The requirement to obtain the affidavit and the ability to enforce that requirement while the suit is pending and certainly before trial are the two key aspects. Both of those aspects can be enforced using existing federal rules without conflicting with any of them. And that's our only point, and that's what the trial court did here. There was no conflict.
Can you just help me to understand why, and this is kind of particular. You say the case has to be dismissed if the affidavit isn't filed, but when I look at the actual language of the statute, it says the clerk of the court shall refuse to file the complaint and it should not be docketed with the court. That is actually technically a different dynamic than having accepted it and it being dismissed. And so what I don't understand is why we don't just have a plain conflict with Rule 3, which is the rule that tells us in federal court when a case is commenced, when you file it, when it's docketed.
Sure.
This says the clerk has to refuse to docket the case, not that the judge has to dismiss it. And I think that's a relevant distinction. Am I wrong about that?
I don't think it's irrelevant, but first let me say the statute also doesn't tell you what to do if more time is given and the plaintiff never actually produces the affidavit. Case law does. It's very clear under Delaware law that the case has to be dismissed. Second, to the extent there is a conflict with Rule 3, I think Walker, this court's decision in the Walker case, which is about commencing a case under Rule 3 and whether commencing a case under Rule 3 conflicted with a state requirement that said you have to commence a case for purposes of a state law cause of action through service. And what the court said is, Rule 3 is the mechanism by which you start the federal case for federal deadlines. But it doesn't do away with other state law requirements that have to be satisfied in order for a particular plaintiff to maintain a cause of action. So there's no conflict here. Under the terms of the statute, you can get more time. So clearly, you can commence a case without filing the affidavit.
But that's not what it says. I mean, if you look at the statute, I'm looking now, it says that the court may, upon timely motion, grant a 60-day extension for the time of filing the affidavit. But we know that if the affidavit isn't filed, the complaint isn't docketed with the court.
Well, it doesn't say quite that. It says you can seek the motion. Clearly, it has to be on the docket for the court to grant the motion. And you're given more time while that motion is pending with the court. So even the plain terms of it don't actually prevent docketing of the case absent filing of the affidavit. But I do agree with you, Justice Jackson. You know, Rule 3 governs commencement in the federal system. And then the question is, what do you do with this requirement? Petitioner's position is it can never be enforced ever in any federal case for all time. Our position is if it can be enforced using the federal modes of enforcement without conflict, then you need to give it effect.
Suppose Delaware required not one affidavit of merit, but 4 affidavit of merits, each from a different doctor. So you had to find 4 doctors. And suppose that Delaware, instead of demanding that each of these doctors said that there were reasonable grounds for a mal suit, said that each of these doctors had to say that, in fact, there was a violation of the standard of care. So you had to find 4 doctors all saying, testifying that there was a violation of the standard of care before your lawsuit really began. Fine?
Well,
got to be fine under your theory.
I'm going to say fine because states almost universally across the country require as a condition of proving a medical negligence case, typically, experts demonstrating breach of the standard of care and causation. That's typically 2 experts, sometimes more than that.
Eventually, at a certain point in the
Sure.
process, but Delaware is saying right now, when you start the suit, you have to have in your back pocket 4 doctors who say there was a violation of the standard of care. Under your theory, Delaware could do that. And New York could do something similar with respect to a different kind of lawsuit. Then California could do something similar with respect to a different kind of law school suit. All of these requirements effectively forcing a person to prove her case before the case really gets started. That's like if there's anything you know is a violation of the whole idea of the federal rules, that's it.
Well, again, I think you have to do the Erie analysis, and that was the same concern.
You don't have to do the Erie analysis because the federal rules are there to tell you that that conflicts with it. You never get to the Erie analysis.
So, understood, Justice Kagan. That was sort of the theme of cases like Woods and Cohen, was this argument, we can't be having states impose these
Are
conditions.
you really saying that Wood and Cohen are like the hypotheticals that I just gave you, which forces a person to prove its case in the first week?
Well, the Delaware requirement doesn't require a plaintiff to prove its case in the first week. It just has to show consultation with an expert that demonstrates reasonable grounds, not plausibility under Rule 8.
Yes, but I just said there's no way under your theory that the reasonable grounds is any different from a likelihood of success, is any different from, yes, there was a violation of the standard of care.
Oh, I don't think it's I don't think it's nearly that onerous. And the Delaware Supreme Court has made very clear that it's not that onerous. Literally, the affidavit needs only say exactly what the statutory text or the functional equivalent says, and that was the Dishman case from Delaware Supreme Court in 2011. So it's a prophylactic measure. I do think it's similar to a bond requirement. Do this thing, satisfy this requirement. If you can't do that, you can't maintain the cause of action. And that's all Delaware is doing. And other states have done it to good effect through their medical malpractice reform laws. And as the American Hospital Association brief explains, they have been very, very important in limiting frivolous medical negligence cases just like this one, which was filed by a pro se plaintiff who couldn't obtain that sort of basic prophylactic measure. So if Cohen can condition a shareholder derivative suit on obtaining a bond, it's really hard to understand why Delaware can't regulate claims for medical malpractice by requiring an affidavit. And if petitioners or if defendants can bring those issues to the court using the federal rules without conflict, Hannah says you have to enforce those requirements because the modes of enforcing them don't have to be the same, but the law has to be applied the same across the two judicial systems.
You've used the word conflict quite a bit. How are you defining that?
I define it the way that Hannah defines it.
How about Shady
Even
Grove?
Shady Grove. That's actually a great case.
Answers the same question. Yeah, that's different than.
It answers the same question, but the court made clear the two could not coexist at all. The trial court in Shady Grove.
Well, just because they were different.
Not just because they were different, Your Honor. Remember, in Shady Grove, the case was dismissed at the outset on a jurisdictional ground because the court said, I can't use the class action device at all to package claims together and meet the amount in controversy requirement. So it was a ruling that said, I can't even look at Rule 23. That was a conflict. There was no way at all to apply Rule 23 the way that the trial court had applied it there. That was an unavoidable collision, answering the question in dispute in a way that required displacing state law in Shady Grove. So we're using the term conflict or collision in the same way as the court was using it there.
And you don't think, or do you, that conflict encompasses when they're just additional requirements?
I don't, because Walker tells us that's exactly how you don't read conflict. It said...
Well, but Shady Grove says additional requirements. I mean, that's in Shady Grove on 401. You're right. I mean, obviously, Shady Grove struggled with Walker. It's in one of those classic footnotes. So I take your point on Walker, but in the text of Shady Grove, it was talking about additional requirements, at least as I read it.
Well, the way I understand...
And that, in turn, would answer the same question, which was the test Shady Grove set, which was a little more refined than the prior tests, at least as I've read it all.
I think Shady Grove didn't do away with the requirement that the conflict has to be real and actually presented in order for federal courts to just do away with state statutes in their entirety in federal court. I think that much was true of the New York statute in Shady Grove. And it's been true in other cases too. Semtec, which interpreted Rule 41, it said, well, we could apply this to preclude the state law of claim preclusion, or we could apply it to incorporate the state law of claim preclusion. There it wasn't an on-off switch, and it wasn't we can apply one or the other. The court said, no, we apply Rule 41, but we do so in a way that preserves the substantive state law of claim preclusion. So that's the difference between sort of the Semtec example and the Shady Grove example, where there's just no way to reconcile the two.
Can you take a moment and touch on the Rule 11 argument and the concern that Rule 11 is completely inapposite, and therefore both of you have it wrong when you point to that? The essential argument is that Rule 11 is clearly about the verification of pleadings,
right.
That it's talking about the signature that might be necessary, and that to the extent it's referencing an affidavit, it's in that context. It's not talking about these kinds of affidavits or affidavits in general.
Well, I agree with you. I don't think you need to read 11A to apply to the affidavit of merit requirement at all. That was my point. The pleadings in this case closed. We never said, oh geez, you have to dismiss the complaint and I can't answer it because the affidavit wasn't filed alongside the complaint. And that was my point with Justice Kagan. The affidavit does something different that tell you what's in the complaint and whether or not it can be believed. It's a separate requirement. And the Delaware Supreme Court has made clear it doesn't even restrict the experts or what they can say in the case. If you want to use the expert who provided the affidavit in your merits case, you have to disclose that expert separately and comply with the Delaware rules of civil procedure, which require similar expert disclosures as the federal system because the systems are largely the same.
Thank you.
Thank you, Counsel. Justice Thomas, anything further? Justice Alito? Justice Kagan? Justice Gorsuch?
I hate to belabor it, but just your conversation with Justice Jackson, Rule 11 features very prominently in your brief, but you seem to be backing away from it here.
I'm not backing away from it. We said in our briefing that to the extent that the affidavit has to accompany the complaint, Rule 11A provides an easy answer.
Okay, but now you're saying it doesn't have to accompany the complaint. In fact, it could happen months before, months later.
Which is true.
Okay, so thank you.
Yes.
Ms. Kavanaugh? Justice Barrett? Justice Jackson, anything? Thank you, Counsel.
Thank you.
Rebuttal, Mr. Yarger?
Thank you, Your Honor. Just a few points. I'll just start with Justice Gorsuch's point about whether this is privileged under state law. Doesn't say the word privileged. It only applies to discovery and medical negligence actions. The federal court would essentially have to procedurally freelance to sort of say, well, Delaware probably wants this to be privileged in order to actually make it work within the federal procedural scheme. So I just don't, this is news to me that it creates a privilege. And who even holds this privilege? The doctor, the plaintiff, it's unclear. We're not trying to overrule anything. We're the party here saying apply Shady Grove. Use the answers the same question framework and reach the result that inevitably requires, which is that this Delaware statute answers the same question as many federal rules of civil procedure, and to the extent that it does, it's in conflict. Cohen didn't govern pleadings. It was a case about whether or not you have to post bond. The court in the case said things like, it creates a new liability that didn't exist before. That makes it, manifestly substantive. It has nothing to do with the merits of your claim. It's simply a security against losing the suit. Walker is even further afield. It's a case about whether a corporation that doesn't appoint a corporate agent in the state can maintain a suit in the state. I'm sorry, not Walker, that's Woods. Walker is about Rule 3 and whether for certain state statutes of limitation, the commence the action language of Rule 3 was intended to displace the state statute of limitations. That just has nothing to do with the nature of the Rule 3 conflict, for instance, in this case, which literally the Delaware statute changes when the answer is due. I mean, this is about commences the action. Justice Kagan's point that you have to prove your case before it's even started, that is the fundamental thrust of this Delaware law and laws like this. You need to come to court with evidence that was discovered outside the discovery process, and you need to not only to have it, but you need to submit it, and you need to do it through a certain procedure. And so even if you thought consultation with an expert, which is how respondents have framed it, might be permissible, say in your complaint, I consulted with an expert, but actually having them then sign an affidavit and give it to the court is a whole different thing. These affidavits are extremely hard to procure. My client's treating physician said that he had a good malpractice case, but wouldn't sign the affidavit because it's a big deal to sign these affidavits. So they're more than a barrier. Even if you have a meritorious case, they can be a barrier that keeps you out. In terms of talking about, what could they require? How many affidavits could they require? What kinds of affidavits could they require? We sort of have been using the 12 nuns formulation, to bring a contract action. You have to have 12 nuns, swear that this really is the parole evidence that would support your contract claim. It would allow states to smuggle in whatever procedural system they want through the back door of, we're going to label it an affidavit. Shady Grove, as I read it, said, the question is what claims can be maintained as a class action. So it was all about, could you add requirements to Rule 23? And the court said no. I think that this case is really quite on all fours with Shady Grove. I just want to say the federal rules answer the same question the Delaware law answers, and they answer them differently. Under Hanna and Shady Grove, that's dispositive. We urge you to reverse.
Thank you, Mr. Tutt. Mr. Yarger. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.